Hello class, and welcome to your Chapter 10 lecture where we're going to be discussing economic and restorative justice reparations in the criminal justice system. So learning objectives for today's lesson are that by the end, you will be able to examine how restorative principles and practices differ from traditional criminal justice practices, explain the different forms of restorative justice, including victim-offender mediation, victim impact classes, family group conferencing, and sentencing circles. You will also be able to compare and contrast economic or monetary sanctions that are used in both restorative and traditional criminal justice systems, including restitution, community service, fines, fees, and forfeitures. So let's begin by discussing the differences between community justice and restorative justice. Community justice is a philosophy that uses community stakeholders to control and reduce crime, as well as to rebuild community relationships through things such as community policing, community courts, and restorative justice. So restorative justice is a form of community justice. Looking at restorative justice then, this is a sentencing philosophy that's going to emphasize the offender taking responsibility to repair the harm that they've caused to the victim, as well as the harm they've caused to their surrounding community. So looking at procedural justice theory, this assumes that those who perceive they were treated fairly and respectfully during legal proceedings are going to be more likely to comply with court-ordered conditions. So when an offender is able to contribute more to the outcome, when they're less coerced into accepting the results, and when they have more support from the community because the community is involved, they're more likely to be successful and complete those court-ordered conditions. But this depends on the degree to which citizens actually exercise control over the decision-making process, the degree to which procedures are used consistently with similar cases, that those procedures operate without any bias, using the most accurate information. And we have to give an opportunity for citizens to appeal the results if they do feel they were treated unfairly. And we need to make sure that citizens are treated respectfully and that their opinions are valued, and that the citizen themselves are valued. So let's take a deeper look at restorative justice. Restorative justice is again community-based, and it comes from a combination of mainstream American criminal justice along with the indigenous justice that was practiced by the Native Americans. So we have a focus here on the victim, the offender, and the community. All three must be involved to have successful restorative justice. It focuses then on reintegrative shaming, not stigmatization. So stigmatization only serves to reject the individual by labeling them an offender, whereas reintegrative shaming rejects the behavior, not the offender. It also allows the victim and community to disapprove of the criminal behavior, but it seeks to repair those weakened social bonds that were caused by the crime. So we want to make sure that we're not only shaming that behavior, but that we're giving the offender an opportunity to once again repair the harm that they've caused and to make it right again with their victim and their community. So there are 6 principles for restorative justice, and they share 6, so there's 6 commonalities that are considered the principles of restorative justice. So 1, there needs to be at least one session that's held in the community with a goal of allowing the victims to communicate to the offender how that crime has affected them. A reparative plan is developed and will be accepted by both the victim as well as the offender. The victim and offenders must also volunteer to participate in this type of justice. And the parties rely very heavily on community partners and volunteers for help in coming up with this reparative plan. The offenders here must accept responsibility for their crime. They must admit guilt, and agree to comply with the reparation plan that was put in place and agreed upon. And finally, while restorative justice can take place in jails and prisons, most forms are going to be community-based and used as an alternative to traditional court processing or as part of a diversionary process. So trying to divert these offenders from even going into the system or going into jail or prison. So we can break these down by those that are done pre-conviction and post-conviction. Those that are pre-conviction include victim offender mediation, conferencing, and sentencing circles. Those that occur post-conviction are things such as reparation boards and victim impact panels, and we're going to dive deeper into each of those now. So victim offender mediation has existed in the United States since the early 1980s, and there are now thousands of programs worldwide. So how it works is that a mediator is going to meet with the victim and the offender separately first. They'll then discuss the facts of the case, and there's a big focus on repairing the harm to the victim. So the victim will agree to participate so that they are able to seek restitution. They'll be able to oversee the punishment of their offender, and they're given the opportunity to share their grief with the offender. Looking at victim satisfaction and the outcomes of victim offender mediation, many victims do report being satisfied with case outcomes. They report they're more likely to receive restitution payments, and they're less fearful of being re-victimized by their offender. Some concerns, however, are that this type of mediation gives the victim's perspective more weight, and the offender's perspective is not addressed enough. So maybe the reasoning for why the offender engaged in that behavior. There's also no strong evidence that this type of mediation reduces recidivism, though one study showed a 34% reduction in juvenile offenders. Then looking at conferencing. So it originated in New Zealand, and it's typically going to be used in juvenile cases. It's also been referred to as family group conferencing. So it involves support from all of those who are involved in both the victim's lives and the offender's life. So it does require that the offender takes responsibility for their behavior and for their actions. During the conferencing, they'll go over the facts of the case, and every person is given an opportunity to talk before everyone together comes to an agreement on a reparation agreement is what it would be called. So the victim must voluntarily participate. And the main goal here is to strengthen and empower both families and peer groups of the offender and the victim. So again, you'll have maybe friends, teachers, mentors, maybe religious leaders, or those who are involved in, again, the victim and the offender's lives to all come together. The offenders who participate in conferencing did have lower recidivism rates, and those who did recidivate after participating in conferencing did so farther along down the line, so it wasn't right away. And RISE, which is Reintegrative Shaming Experiments in Australia, is one example. So in this program, violent offenders were shown to have lower recidivism rates, but there was no difference in recidivism rates for those who engaged in property or alcohol-related offenses. Looking at sentencing circles then, these are based on the idea of tribal justice using the medicine wheel, which you'll see here on the right, and it heavily relies on reintegrative shaming. So it's going to focus on the physical, emotional, mental, and spiritual aspects of an individual. So with that, the blocks here up top will show you who's going to be involved in sentencing circles. And while it may seem that conferencing had a lot of participants, these sentencing circles are going to involve the largest number of participants, and they're also the most organized. They're going to be most effective in your smaller communities because the goals here are for the offender to do some soul searching. What is it that they truly want here? Do they want to continue engaging in this type of behavior? Or do they want to repair the harm that they've caused to their victim and their community? We also want to make sure that that offender reestablishes trust so that the family, friends, coworkers, and the community members, and especially the victim, are able to trust that offender once again and to rebalance all of the relationships among these different participants. So the purpose here is that all of these different participants will be able to arrive at a consensus of how justice can best be achieved for that offender. So going into post-disposition, we're going to start with reparation boards. So reparation boards have existed in the juvenile justice system since the 1920s. They were typically used for nonviolent misdemeanors, both in juvenile and adult court. The victim is not always involved in reparation boards though. So you'll notice in all of the ones we spoke about previously and most restorative justice programs, the victim is involved. Reparation boards though, they may be involved or they may not. So they may provide written or oral impact to the board, and the reparation board themselves may partner with faith-based organizations, and they're going to involve more community, again, than victim participation. So they rely heavily on the community and volunteers to distribute justice. So the responsibility of the board here is that they're going to be a mediator between the court and the offender. So the board will meet after the offender is convicted. So again, post-disposition, they're going to meet after the offender is convicted, and they're going to decide how the offender will best repair the harm and reform their conduct. Typically, the conditions that they're going to be given are less stringent than that of typical probation. They will then also give reports to the court on the offender's compliance, and they'll be able to recommend sanctions if the offender is violating the reparation plan that was agreed upon. So again, it's going to rely heavily on volunteers and community members to mentor and supervise the offender rather than probation departments. And then victim impact panels. So these victim impact panels don't necessarily include the exact same victim that was involved in that offender's case or that offender's offending, but it's going to be one or more confrontational meetings between a willing offender. So the offender has to be willing to participate in a victim impact panel. And it's going to involve the offender as well as those whose lives have been affected by that same type of crime. So an example would be Mothers Against Drunk Driving, who will go into, say, prisons or jails or even different community programs and speak to offenders who have driven drunk or have DUI charges and explain the impact that it has had on them. So while it's not the same victim, it's victims who have experienced the same type of harm and who have been involved in similar crimes or who have been the victim of similar crimes. The purpose here is simply to help offenders make better decisions in the future. So the idea is that if these victims can explain how it's impacted them, that the offender will internalize that and be more empathetic and realize that they shouldn't engage in that behavior. However, research does show mixed results in the effectiveness of victim impact panels. It doesn't say whether they're truly effective or not. Another example would be those victims of domestic violence, maybe speaking to a group of domestic abusers. So when we look at the effectiveness of all of these restorative justice methods, the way we can measure how effective they are a few ways. We can look at recidivism, as always, that's usually our number one go-to in the criminal justice system. Has the offender reoffended? But we can also look at how satisfied was the victim with the outcome as well as the process in general. Did the offender make their restitution payments? And what type of cost savings did we see by using restorative justice rather than traditional justice methods? So rather than incarceration, rather than probation, which can be costly, how much money did we save by using community members and volunteers to ensure justice was served? Restitution is also more likely to be paid when it's part of a restorative justice program than when it's part of traditional court processing. And restorative justice is less likely to be accepted by victims of violent crimes than it is of victims who have been victimized with property crimes. So it may be harder for a victim of a violent offense to sit across from their offender and want to work with them than maybe a victim who had their property taken or damaged. So continuing with the effectiveness, we have seen that restorative justice methods do have a positive impact on recidivism of juvenile offenders, though it's less successful in reducing the recidivism of adult offenders. Again, it is cost effective, it is saving money because you're using community members and volunteers and faith-based organizations, maybe some nonprofits, to help deliver justice, and using that reintegrative shaming where we're not using retribution and we're not going to shame the offender, but we're going to bring them back in to the community by using community members rather than your traditional and typical criminal justice departments and entities. So recidivism, when we look at when it's decreased, recidivism is decreased when the victim and the offender were able to have direct contact through the restorative justice method. So for example, maybe reparation boards would not be quite as effective at reducing recidivism because the victim maybe wasn't involved. Recidivism, however, has been shown to increase, interestingly enough, when the victim and offender developed the reparation plan and came to a consensus together, when the community was present, and the more satisfied the victim was with the results, actually showed to increase recidivism. We don't know exactly why, but that's what the research has shown. So what are some of the victims' concerns regarding these restorative justice methods? Well, they feel that sometimes restorative justice can be too focused on the offenders. So while it does include the victim and it gives them an opportunity to be involved and come to a consensus, the main focus at the end of the day is still that offender and making sure that offender is going to repair harm and restore harm and what the offender can do to fix that. There's also criticisms regarding the emphasis on reintegrative shaming rather than using that retribution and stigmatization, which some victims would like to see. I mean, let's be honest, if you've been the victim of a crime or the victim of anything, sometimes you really just want to see that person suffer. You don't want to necessarily accept that person back into the community. You may not be ready for that. And victims may have a very difficult time self-advocating, which is required in a lot of these restorative justice practices. So a victim may not have the confidence, they may not be good speakers, they may not know how to even express how that crime affected them. And if they're being asked to sit here with all of these different parties, the community, volunteers, organizations, the offender, and explain how that crime affected them, they may need a victim advocate to come along with them, but they may not know that they have the right to that, or they may not know where to find one. So they may have a difficult time voicing themselves in these restorative justice methods. So let's switch gears a little bit. That was your restorative justice. Now we're going to go into the economic types of justice. So we're first going to look at restitution, which is again tied to victims. So it's a court-ordered payment by an offender to either the victim or the victim's family if the victim is now deceased, which is going to cover tangible losses. It's very important that you understand that. Restitution is for tangible losses that occurred either during or following the crime. There's a history of restitution that can be seen in the Old Testament of the Bible, as well as in the Code of Hammurabi. So Jeremy Bentham, who was a British philosopher, believed that restitution was an essential means of the offender, of making the punishment for the offender fit the crime. And Elizabeth Fry, who was a Quaker prison reformer, believed that restitution was a step toward rehabilitation. So what are the benefits of restitution? Well, we can really thank the victims' rights movement for making advances in restitution. And by that I mean that laws passed in the 1990s were able to increase the offenses for which restitution could be sought. So prior to the 1990s, a victim of one of these types you see listed here, either an offender not paying their child support, being the victim of a property crime, or delinquent acts, so those from juveniles, domestic violence, and being sexually abused or exploited, you were not able to seek restitution for those. So losses that are eligible for restitution are things such as a loss of income as a result of physical injury or the time the victim had to spend in court, medical expenses, transportation to court hearings, and sometimes victims will be subpoenaed to attend the court hearings, so they must go. The ability to pay for childcare during those hearings, as well as counseling, sexual assault exams, HIV testing, as well as occupational or rehabilitative therapies, restitution payments so the victim can move, for meals, and for burial. So these are all tangible losses. So again, some of these expenses are those only related to hearing attendance, not the actual crime itself, or direct losses from the direct crime. So what are some problems that we have though with restitution and ordering it? Well, there's an underutilization of restitution in general. This could be due to a lack of victim participation in the system. They either don't want anything else to do with it, they want to move on with their lives. They don't have the documentation to prove the amount that's owed to them, or just a general lack of knowledge about restitution. So we also need to take into account the defendant's indigence or their ability to pay. For juveniles, the courts are mandated to take into account their future ability to pay, or even the family's ability to contribute to those restitution payments. Sometimes it's hard to determine the proper amount. If you think to the types of losses I just discussed, it may be hard to quantify some of those, or it requires a lot of documentation and a lot of paperwork to arrive at the right amount. And it's difficult to obtain restitution for certain types of victims, so those of human and sex trafficking, because again, how do you quantify the losses that you've experienced as a victim of that type of crime? Now, if we look at indigent offenders specifically, an indigent defendant cannot be cited for contempt or sent to prison for failing to pay restitution. However, if a defendant can afford to pay their restitution, but is simply refusing to do so, then they may be incarcerated depending on their jurisdiction's laws. So if we look at the case in 1993 here, the court determined that indigence at the time of sentencing does not bar restitution from being ordered. So just because a defendant is indigent at that moment, or maybe they don't have a job at that moment, if they are able-bodied and they can obtain employment, then the court can still order restitution based on their future ability to pay. Then in Wooten v. State, 2001, the court determined that a defendant ordered restitution as a condition of probation cannot be incarcerated for failing to pay that restitution. And finally, declaring bankruptcy does not excuse an offender from paying restitution, which I'm sure a lot of victims appreciate. So an offender cannot simply just declare bankruptcy and get out of paying their restitution. I can tell you, for example, we had one juvenile offender that was ordered to pay around $70,000 in restitution because he and another juvenile burnt down a cabin, and it was valued at about $70,000. I believe he had mental and cognitive delays and disabilities, but the court determined at the time that he did have a possible future ability to pay that restitution, so it was still ordered. So how do we determine the restitution amounts? So restitution is typically determined by probation officers, but then the court will order the amount. The amount is usually based on what type and the amount of harm that was done to the victim, the existing financial obligations of that offender, again, as well as their ability to make those payments, and whether the victim was insured or partially at fault for the victimization. A defendant is actually also given the opportunity to refute restitution amounts and can request a separate restitution hearing in which the judge will then simply make a ruling on the amount of restitution. And in these cases, the victim will typically be called as a witness. The prosecution will present all of that documentation and evidence to prove the amount that's being requested. The burden of proof in restitution hearings is a preponderance of the evidence, so it's a bit lower of a threshold. And in some states, the parents of juveniles can actually be required to pay restitution as they're viewed as the responsible party for that youth, and they should have been responsible for that youth while they were engaging in whatever delinquency it was that caused restitution to be ordered. So how do we collect restitution? Well, typically there'll be a payment schedule and it'll be dispersed to the victim through probation offices, day reporting centers, which we talked about last week, or even restitution centers, which we talked about in a previous week. Collection rates range from a very low 4.5% up to 32%, depending on states. Some states have better rates of restitution collection, and it's also, again, going to depend on the type of programming the offender is placed in. For example, if they're placed into a restitution center, they may be more likely to make those restitution payments and to reimburse the victim quicker because that center is taking their paycheck and ensuring that that's being paid, as opposed to an offender who is just placed on probation and is responsible for making sure that they're going online, logging in, and making that payment themselves. It does show that less than half of federal felony offenders have paid restitution in full by the collection date that they were given, although we can increase collection with 3 different methods. So threats don't work. You can't threaten an offender into making restitution payments. I mean, you can try, but you're not going to be very successful. So instead, you can use letters as reminders. Hey, here's a reminder of how much you still owe. Here's how you can make payments. You can collect the restitution prior to sentencing. So having sentencing being partially dependent on restitution being paid, as well as using restorative justice methods. So community service falls right in line with restitution. So community service is going to be an unpaid service to the public to help compensate for harm done by the offender. So while restitution is to repair the harm to the victim, now we're focusing on the community. It is very cost effective, however, it's underutilized. So examples of community service can include landscaping, removing graffiti from buildings, picking up trash, and even painting buildings. Typically, this is going to be ordered by a judge as part of their conditions of probation. And if we look at the history of community service, it actually began in Alameda County, and it was used as an alternative for low-income female traffic offenders as an alternative to them having to pay fines. Then more programs were established in the 1970s for juveniles and nonviolent offenders. And if we compare the English model to the U.S. model, the English model used community service more as an alternative to a prison sentence for low-level theft and drug offenders, while the U.S. model uses it as a punitive sanction, ordering between 100 and even 1,000 hours as part of the probation conditions. So let's look at that a little bit more. There are 4 purposes to ordering community service. The first is restorative, so it can help nonprofits that serve poor communities with having essentially free labor. It also serves the purpose of being fair, so it's an alternative to paying fines for those offenders who are indigent or who don't have the ability to pay them. It can also be seen as punitive, so in that the offender's time and freedom is being partially restricted while they're engaging in the community service. But for wealthy offenders, For those of whom money is no object and it doesn't matter how much you would give them in fines, it can be a way as a punitive sanction for those offenders to repair the harm to their communities. And finally, it can serve a rehabilitative purpose. So offenders will gain an increased self-esteem for knowing that they've helped someone else. When we look at prevalence, it's usually about 22% of felony offenders and 26% of misdemeanors that are given community service to complete. And you can see here on the right side of this chart where you have the different types of punishments or offenses and their classifications, as well as the minimum and maximum hours that they can be given. Now, this is definitely more for adult offenders. Juveniles, I will say in Pennsylvania anyway, we typically order somewhere around 25 hours that the offender will have to complete. For misdemeanor offenses, within a 6-month period. For felony offenses, they may be given 50 hours of community service. If they were found adjudicated, or if the juvenile was adjudicated on multiple charges, you typically would just use the highest graded offense. So if it's a felony, even if they have a couple other misdemeanors, you're not adding up all of those hours of community service. It would just be 50 hours total. So a couple considerations that must be taken into consideration when ordering an offender to complete community service is their employment status. So if the offender is employed, you may not want to order community service because, again, I'm beating a dead horse here, but employment is the number one factor that we want, and number one pro-social activity we want offenders to engage in. So we want to make sure that they're employed, but if they're not, in some jurisdictions, they'll actually use 8 hours of community service to equal 1 day of jail confinement when it's being completed when community service is ordered in lieu of the offender being incarcerated. So long as that offender is engaging in those 8 hours community service a day, it will equal 1 day of them essentially having been in jail. So how effective is community service? Well, completion rates vary. So probation typically won't be extended just because the offender did not complete community service. Again, this is typically, though, for those offenders who are paying their fines or doing everything else right. Maybe those who are employed, they just don't have the time to complete the community service. Not for those who just are willfully being slugs sitting at home and not completing their community service hours when they could be. There's wide public support for community service, for the use of it, and it shows lower rates of recidivism when the offender is actively engaged in the community service activity. So how do we evaluate and expand community service programs? Well, we need to make sure there's clear goals and objectives for the community service. So the offender needs to understand that they're completing this maybe as a diversion to going into jail, or they're completing it in lieu of making fine payments. So you need to attach a clear goal and objective to that community service for the offender to be actively engaged and for it to reduce recidivism. So let's look at the difference between now fines and fees. So we talked about restitution, which were payments to the victim. Now fines are a monetary sanction that's going to be imposed by a judge. Fines are tied to the severity of the offense, so the amount is going to vary based on that. They are viewed as a punishment and can be imposed as either a sole penalty, so the individual can just be fined, or it can be in addition to other penalties. Typically, you'll see it as a sole penalty when the defendant is an organization or a corporation, not when it's an individual defendant, because an organization as a whole cannot go out and complete community service. You can't put an organization in prison, so you'll assess a very hefty fine. The ability to pay is not up for consideration in state cases, so fines must be assessed. And because of this, they may punish indigent offenders unfairly. So for example, the average Washington fine is about $1,400 for a felony conviction, though the actual rate can tend to be closer to $11,500 per person when you couple their prior criminal histories all together. So can we revoke probation for non-payment of a fine? Well, Bearden v. Georgia in 1983 said that probation cannot be revoked solely due to the offender's inability to pay that fine or restitution, because it would then violate the Equal Protection Clause of the 14th Amendment. However, an unwillingness to pay can result in revocation of probation. We've also shown that threats of violating the probation can increase the offender's payment of their fines. And when we look at the Victim Compensation Fund, this can be part of the fines that an offender is ordered to pay. And part of that money goes into the Victim Compensation Fund, where the offenders pay in, and then the fund is used to compensate victims of violent crimes for losses that are not covered by restitution. These are things such as medical and counseling expenses, loss of earnings for missing work, loss of support, sometimes relocation won't be covered, funerals, and even crime scene cleanup. So now we're going to look at fees, which are different than fines. So fees are a reoccurring court-ordered reimbursement for the administration of justice. So it's the government's attempt to recover expenses that are incurred as a result of the investigation and prosecution process. It's important to note here that acquitted defendants, so those who are found to have not committed the crime, do not pay fees. And fees are not considered punitive, so indigent defendants cannot be required to pay them. Offenders also cannot have their probation revoked if they're making an effort to pay these. So state and local courts do heavily rely on the payment of probation or fees to make up for budgetary shortfalls and to help even generate revenue for the states and localities. So a concern here is that you could have a very compliant offender who's making their monthly fee payments being kept on supervision longer, just so that the state and local courts can make more money by having that offender continue to pay them. And unfortunately, this tends to turn probation agencies and probation officers into a collection agency. So it unfortunately diminishes that probation officer's role of being a change agent and wanting to be there as a help for the defendant, when they have to simply act as a collection and make sure that they're getting money from the offender. Lastly, we're going to cover forfeitures. So forfeitures are government seizure of property that was either illegally obtained or property that was used in connection with illegal activity. So the purpose here is not punishment, but rather to ensure that offenders do not keep illegally obtained profits and to deter people from committing crimes either in their home or business. So for example, I may not want to sell drugs out of my home because if I do, they may take my home or attempt to take my home. However, the forfeiture cannot be grossly disproportionate to the seriousness of the offense per the Eighth Amendment's excessive fines clause. So for example, if I'm selling drugs out of my house, it would be unreasonable for the state to try and simply take my house because I'm selling drugs out of it. However, if they can prove that I have used the profits of my drug sales to purchase my home, then in that case, they could attempt to take my home from me as part of a forfeiture. So in criminal cases, this is going to occur after the conviction of the offender, but in civil cases, this can be for any criminal event, and the burden of proof is lower here at a preponderance of the evidence. So you may see some states taking offenders to civil court rather than doing it through the criminal courts because there's a lower threshold for a burden of proof, and it can be for any criminal event. So in sum, I know that was a lot. Community justice is a philosophy that uses community efforts to help control and reduce crime. Restorative justice is a form of community justice and emphasizes the offender taking responsibility and repairing the harm to their victim. It's victim-centered and relies heavily on community partners and volunteers. Restitution is a payment made to the victim by an offender for tangible losses that is a direct result from the crime. Fixed fines are viewed as flawed because indigent offenders are disproportionately affected by them. Remember, fines are fixed to the offense severity. Fees, however, are monthly payments that are attempting to recoup administrative costs for administrating justice. Forfeitures are material items or property that's seized as a result of criminal activity. And collection rates for all of the above still tend to be very low in the grand scheme of things. So that was your Chapter 10 lecture. I hope you enjoyed. I know we're about the 40-minute mark, so I hope you all have a lovely week.